7, 6, 5, 4, 3, 2, 1.
Do you have constitutional questions? Get constitutional answers. We'll be answering your constitutional questions live, so get ready to call in now. Are you a prosecutor, law enforcement officer, or local government employee? Want to make sure you are executing the laws in a constitutional manner? Are you a city council member, township board member, or state legislator? Want to ensure the laws you pass are constitutional? Perhaps you're a citizen who wants to know the proper limits on government and the protections for your God-given liberties. Regardless of your role, call me, Constitutional Attorney Catherine Henry, with your constitutional questions during our live call-in show now at the phone number listed on the screen. And remember, together we can restore freedom.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
That's a little better. Just finishing eating a piece of toast, so I'm kind of hungry, but we have a show tonight, right? So didn't want to, I was like, I'm going to eat for the first time on camera and nobody's going to care. And I was like, that's insanely rude. So I couldn't do it. I had to finish chewing as quickly as I could while Emma was doing the Pledge of Allegiance. So anyway, let's see if I remember all the buttons I'm supposed to press here today. We have our live call-in show, which is what this is. And it's terrible that when I put something, the words up at the top, that somehow that means the entire thing moves up and then I have the Restore Freedom on the top of my head. So anyway, all right. So hello, everyone. Doing a quick look through here. Yes, hello. Let's see. Liberty Warrior, you're gonna say I need to look at a video by sending a link during the live in the chat. How am I supposed to do that? I'm not, dude. If I'm supposed to look at a video, send me a message some other way. Don't do that. Anyway, do I watch 4 boxes? I've never heard of that, so I don't know what it is or why I would watch it, but let's see. This would be to go over now. Just found it. Dude, I'm not going to watch a video. My internet, you know darn well my internet has had enough issues throughout the couple of years that we've been doing this, since I've been here anyway in this house, that I'm lucky when the live stream just works. So I'm not going to press my luck and try to watch a video while doing the show tonight. But that's why I was hoping I'd get, with Foshin or DirectD or somebody, and we'd do some joint work on having them play a video, and then I could do commentary on it. So maybe if you want to tell me what the video is about, we could start there. But anyway, to those of you who are just stumbling across this, I highly doubt it because we don't have a ton of people in the chat right now. But if you happen to be new and you're just stumbling across this, or someone has referred you, hi, I'm Constitutional Attorney Catherine Henry, and this is our live call-in show. I've been doing this twice a month for the last several months. I've always answered questions ever since 2020 when I started doing Facebook Lives and then YouTube Lives. And You know, there were all these different things going on with executive orders and state statutes and things going on. I would have a lot of questions popping up in the live chat. Sometimes people would text me and I would try to answer everything during those. And then once I moved down to Florida, then I tried to do a weekly show where we'd go over certain topics and we'd often have a guest. And I put tons and tons of time, I mean, hours and hours of prep work in, and we would have less and less people watching. So, I mean, like, why fight for freedom when everything's totally okay, right? You know, just go back to what you were doing before COVID started. Anyway, so I figured that's probably not the best way to go, especially that was over last summer. I decided I had to reel back and not do as much of that. And we were going to try doing these kinds of shows because I also took in a 15-year-old at the time, in addition to my own children. And so I knew I needed to spend some time on her and with her and figuring out what she needs and all that fun stuff. So anyway, so things changed, and now basically the only videos I've been doing for the last several months are these live call-in shows. So as you can see on the screen, it says call in now, because that means you can literally call the number that's on the screen, 616-303-0093. You can call that number, and assuming the technology is working tonight, I will be able to answer the phone call and we will be able to hear each other. Some of those steps have been hit and miss in different episodes. But anyway, if you call in and you have a legal question, a constitutional question, keep in mind, I am an attorney licensed in several jurisdictions, including the U.S. Supreme Court. And I live in Florida, but I'm not a Florida licensed attorney. I do have a fellow freedom fighter that got me roped into being admitted pro hoc VJ without me asking, but with him asking. And so I'm admitted for his case only, a First Amendment auditing case, out of the Middle District, Federal District Court in Florida. But that's just for his case. So anyway, if somebody wants to continue trying to raise, about $10,000 so that I could do all the character and fitness background checks and fingerprinting and requesting all the records and paying for the bar exam and everything down here in Florida, I'll sit for another bar. I've passed every single one I've taken so far. But what I do is help people for free, so I don't have that money to put out there. Anyway, I do see we have a couple other questions coming in, so I'm going to check. So anyway, Liberty Warrior says, a South Carolina judge puts a guy in jail for 50 days for criminal contempt in a private court. I don't even know what that means. You just mean it wasn't open to the public. Even the other judges are telling him he can't do it. Well, it depends on what the criminal contempt is for. I don't know. I feel like I'm missing something here. I feel like I'm missing a lot of some things here. And let's see, somebody else got a photo enforcement traffic ticket. Let's do this, guys. I'm going to assume that you guys are often going to be talking with each other, because that happens quite a bit. And so if you have a question, I'm going to show you an example question. Do this for me. Okay, so see on the screen, hopefully it's big enough that you guys can see on the screen. If not, you could see the live chat if you're on YouTube. But do me a favor, and I will try to remember to jump over to my internal chat window so that if you are watching on Facebook, or I think it's live on Twitter and LinkedIn right now too, if you happen to be live watching on one of those platforms and you have a question, I will try to remember to flash back over to my tiny little screen to look for comments and questions there. But generally speaking, if you have a question and you're in the live chat and your question is for me, go to YouTube, because it's going to be easier for me to do it that way. Anyway, do it like I did, where I put question in all capital letters, and that way I'll know it's a question for me. And then you can go ahead and ask your question. Otherwise, you might have been saying something that's not exactly for me. Maybe it was part of a conversation with somebody else, whatever. And you did put the @K, and I'm assuming that's for me, but still it's easier for my eyes to see all capital letters question and then lowercase or, appropriate case capitalization for the rest of what the actual body of the question is. So anyway, the question is, I got a photo enforcement traffic ticket checked off. Okay. Ask me that in a minute. I'm going to take the person who's calling first, and we'll come back to that one. Hello, this is Attorney Catherine Henry. Can you hear me?
Good, it's me.
Oh, it's you.
You can understand what you can understand what this is. I was just watching this on another channel. This just happened yesterday in South Carolina. So, guy goes in to pay a ticket in this little town in South Carolina, goes to the clerk of the court to pay the ticket, records himself doing it. Judge sees him doing it, says you can't do that. And he was going to hold him in contempt. And guy leaves. Judge issues a warrant. He finds out several days later that he's got this warrant. He goes back in to turn himself in. Well, they don't do anything now. But they finally pick him up. Judge puts him in jail for 10 days, and the lawyer immediately calls for a mistrial. So they have to release him. Now they schedule another trial date for yesterday. And this time the judge is holding a probate court. That was the problem. It said private. That autocorrect. It was probate. His attorney told him, I can't represent you in this court. This is a criminal contempt. This is a probate court. And he bailed out right then and there. So the guy asked for a continuance for lack of counsel. Nope, judge wouldn't grant it. Judge forced him to represent it. Even the other judges were telling him, you can't do this. And the judge put this guy in jail for 50 days. The court clerks even testified on behalf of the guy that got put in jail. That's how bad things are getting. These judges just do not care.
Well, yeah, that's true. A lot of judges, most judges, unfortunately, don't care. So yeah, I mean, I guess that's something I can take a look at the video, not during live, because my equipment just is not going to do it. I know it's not. And I can try to do one of those videos. Haven't had people send me short videos to go over, to do little videos on. So if you send it to me.
Well, this was a live video that James Freeman just did and finished. And I happened to be watching it right when you came on, and I'm just like sitting here, beside myself, incensed at what I'm hearing.
Yeah.
And I was like, you need to go over this. This is ridiculous.
Yeah. Well.
But yeah, and even the court, because they said that it was an order from the chief judge. Well, problem is there was no order posted anywhere, so nobody would have any idea that the chief judge had decided, well, you can't record yourself paying your traffic ticket. And the court clerks even testified to the fact that at the time he did it, there was no posting, and he never did it again after the judge told him he couldn't do it. And they still arrested him, and now he's in jail for 50 days. No due process, no counsel, just the Constitution, screw it. We're just going to burn it.
Yeah.
That's, and this stuff can't be left to stand. I mean, if we don't collectively, and if you go to James Freeman after this, check it out. The phone number for the judge's office is on there. He needs to get 10,000 phone calls and let him know that the world is watching. We know.
Well, yeah, definitely. It's something, even if you wanted to do, write up a little post about it, I'll copy and paste that into our community page, as well as share it on other social media too. So consider that as well, so we can get the word out there.
This is just getting ridiculous. It's beyond ridiculous.
Yeah. All right. Well, I feel like I need to start answering some of the questions that are coming in. You okay with that?
Oh yeah, you go for it. You didn't seem to, because again, autocorrect put private, and I corrected it down below, and you didn't see it. So I just, okay, I'm gonna call you and tell you what's going on.
Okay. All right. Sounds good.
Carry on.
Okay. All right. See ya.
Bye.
All right, so ladies and gentlemen, that's how it's done. Pick up the phone and call 616-303-0093 if you have a constitutional question. I'm trying to get back to what the okay, so the question that Dave had asked, he checked off contested hearing, will object to the hearing and request a trial by jury preserved by the Seventh Amendment. And then you just say, what say you? Like, what's your question? You got to ask me a question. I say a lot of things. I say I love the Constitution. I say that I hate photo enforcement traffic tickets. When Minnesota was one of the first in the country that did that many years ago when I lived there, I was like, this is shady. This is not acceptable. But anyway, that's, got too many things going on at the same time. Hello, this is Catherine Henry. How are you doing today?
I'm blessed. How are you?
I'm alive. So, there's that. So, are you calling from Michigan today?
Yes, I am.
All right.
I'm in the territory of Michigan. Now, I just had a question about the, is the legislation process the same in every state as far as like a bill becomes a law after going through Senate and all that?
In the most general sense, yes. One of the things I could tell you is Louisiana is like a totally different animal. I did some legal work down there after Hurricane Katrina when I was a law school student, but that was a lot of years ago. And all I remember is that it's totally different. And Minnesota is a unicameral legislature. So it doesn't go from the House to the Senate or vice versa, those kinds of things. But generally speaking, yes, you have a bill that's introduced in either the House or the Senate. It has to pass, and then it goes over to the other House or Senate. And then if it passes, both chambers, then it makes its way to the chief executive, usually in the state, then that's going to be the governor. And then the governor either signs it or some states have provisions for, the governor has 10 days to sign it. And if they don't, it might become law anyway. Or it might say the governor has, they might have different choices there. And so if a governor decides not to sign it or decides to, veto it, specifically, then different states do it differently. Some states have a 2/3 majority as what it goes back to the legislature, and then the legislature has to vote by 2/3 majority if they want to try to pass it anyway. So it's just different. There's a little bit of differences from state to state, but anyway, generally, yes. So I assume you have a follow-up question.
So if a state were to use a law that was never actually passed through legislature, would it be void?
Well, it depends on what you mean by if the state is using it. I mean, generally speaking, you have to.
If they affix a seal to a document that never existed or that was deemed to be destroyed, and then affix the seal to it and then called it legislation, would that be a usurpation of the Supreme Court or the court in general?
Has nothing to do with the court. Court has nothing.
The Supreme Court in Michigan in 1953, People versus Bradley, did affix seals to documents that were already deemed destroyed in 1950, and they called them law.
Okay, I know nothing about that, but generally speaking, the concept of what's happening in court and what's happening in legislation are, they're different because they're different branches of government. So,
Yep. Right. So would that be like, or could there be a claim of usurpation of one office over the other or one branch over the other? A system of checks and balances is being at conflict?
Well, it depends. It depends on, what exactly the issue is. I mean, if you have a specific statute that was never actually voted on by the legislative body and, didn't go through all that appropriate process. I mean, I've never seen where the court, Supreme Court or otherwise, somehow said a statute was passed that, that wasn't. So if I had
In
that.
1953, Michigan, People versus Bradley, the state allowed the court allowed the state to affix seals to it to remedy a situation in which several compiled laws had been in conflict with each other. In Pease versus Peck, 1934, there was two versions of the same law that they found copies of, but they didn't have the original, and both of them conflicted. So they actually deemed both of them unconstitutional because they lacked the seal of the state under the authentication and verification process. However, in 1953, they reenacted these same laws that were already deemed unconstitutional. And the Supreme Court did that in usurpation of the legislative branch, it is to my belief.
Well, again, without me seeing what you're talking about for myself, I can't comment on that. I mean, there's a lot of missing pieces that I would need to see in order for me to be able to have an educated, comment about that or opinion about it. But,
I did comment and leave several case laws for you to read if you happen to have the chance or the time to.
I don't.
To look at the issue that I'm looking at. I know that you're extremely busy, and I want you to know that we do support you out here.
Well, I appreciate that. I do. It seems like a lot of people in Michigan have kind of forgotten about all that I tried to do when I was there and still try to do. But so I appreciate that when I hear that coming from people still there. So what part of Michigan did you say you're from?
Lansing. I'm right near the Capitol.
Oh, okay. Yep. I didn't make it.
I've been to the they have archives and all that, archives of Michigan and all that right there, and all the legislative and everything right downtown.
Yeah. Oh, yeah. And if I had a lot more time, it's definitely something I would have an interest in doing, at some point in Michigan. But and I'll say that is one thing I really miss about when I lived in Michigan. I lived in Midland, then I lived in Belding, then I lived in Hudsonville. I'm not including when I was born up in the UP because that's, like a world away from the capital. But Midland, Belding, Hudsonville, all about, between an hour and a half from Lansing. And it's a doable drive to be able to go and, go to the Capitol, go to the Supreme Court, do whatever, right? Speak at a protest, attend a protest, all those things. And I did hundreds of those in 2020. And now that I'm here in Florida, it is an 8-hour round trip drive to get to the state capitol. Right. And so I've done it once. And I really don't have a desire to do it again. So it's kind of a bummer, but anyway.
Right.
So go ahead.
Oh, I apologize. Go ahead.
No, go ahead.
Oh, I was just going to ask, I mean, honestly, as a constitutional attorney, would the best avenue for relief be under 42 U.S.C. 1983 and superintending control to the Supreme Court?
Generally, I don't think so, because just as a practical matter, I don't think the U.S. Supreme Court or federal courts at all want to get.
Well, I meant to the Supreme Court of the state.
Well, then
ask them to question the validity of.
Yeah, then it wouldn't be a 42 U.S.C. Section 1983 case because that's a federal claim. So,
okay. They told me that I had to exhaust under state remedy first, though. Well, so that includes having to exhaust in the state.
But that's not a state remedy. So that's not always true. I mean, no, you don't always exhaust state remedies before you go to federal court. If there's something that is a federal issue, then you go to federal court. If there's something that's a state level issue, you go to state court. But you don't just bring a federal claim of a federal statute in a state court. Now you can raise a federally constitutional issue in state court. I have done so, but the primary underlying fact pattern and laws raised were state level issues. And even so, the other side was like, oh, you mentioned the Constitution, the U.S. Constitution, so I'm going to remove it to federal court. thinking they were going to scare me because, ooh, then I had to drive to downtown Grand Rapids and go to federal district court down there. I was licensed there too. I didn't give a shit. So anyway, they moved the case, and then I no longer had to pay a $20 motion filing fee, because you don't have a $20 motion filing fee in federal court, but you do in state court in Michigan. So anyway,
Really?
it was cheaper for the 4 motions I subsequently filed, but I did have to pay for parking in Grand Rapids. Point being, you look at the main, if you look at what the issues are, you look at what the claims are, and then you file based on, is the bulk, is your main claim a state level issue? Is it based on a state statute or state common law?
Yeah. The issue is the authentication and verification process of the entire Michigan code, and the entire Michigan law statute.
But no, when I'm talking about the issue that you would raise in court, there has to be a legally cognizable, cause of action. You can't just go to court and just say something's wrong. You have to say there has to be something. Is it
right? You have to produce the corpus delicti. Is that what you're saying?
No.
I have to produce a body or evidence of wrong?
No, I'm saying you have to have a specific cause of action. So a cause of action would be, like you might have a divorce case, you might have a bankruptcy case, you might have a breach of contract or an intentional tort.
So false imprisonment. The false imprisonment was the issue that, in my general case, is what I was raising.
Well, but
that I was falsely imprisoned under laws that were deemed unconstitutional back in 1934, 1935, reaffirmed in 36, 1940, 1950, even. And then all of a sudden in 1953, they can just all of a sudden claim that they're constitutional, slap a seal on them, and call them law. And then also, the other issue is that, okay, I'll just put this out there. The Secretary of State, I have signed documents from that admitting that they don't have any of the public debts except for the current calendar year.
The public debts?
No, public acts.
Public acts.
Yes, the laws of Michigan, the statutes of Michigan.
Well,
they only keep them for their current calendar year, and then they place them in the archive. And archive receives the same document that the Secretary of State does at the time of inception from the Senate. Like they go from the bills and acts the bills are turned into acts and sent and forwarded to the Secretary of State, but they're also forwarded to the archives at the same time. Which the archives in the state of Michigan are not allowed to collect any document that's in current use. So the law at the time of inception is my claim that they're basically making the law obsolete at the time of inception.
No.
And that I was false imprisoned under that.
No, that wouldn't make a law obsolete, just because it doesn't repeal a law just because the archives might have a copy of it. But I don't have all that. I haven't seen any of that myself.
Well, it's also the seal. It's also the seal of the state issue, because I do have the evidence from the archives themselves. I photographed and had several other people photograph that the laws that they can contain in the archives do not have the seal of the state on them.
Well, yeah. And again, that's something I don't feel comfortable commenting on because I haven't seen it directly myself. But generally speaking, you just, as far as what your steps would be, as it pertains to a specific case, you got to figure out what is your cause of action and does it belong in state court or federal court, that kind of thing, where it's talking about what's happening specifically in Michigan with Michigan laws and the procedures used by the Michigan legislature, Michigan Secretary of State, etc. That's something that really does need to be handled by Michigan courts. Federal courts are going to say, you know what, peace out. That's not my, it's not my forte. It's not my arena.
They should say that is the Article 1, Section 10, I believe, issue. Would that be correct or no?
Of the Michigan Constitution?
United States, Article 1, Section 10, separation of powers.
That is not where separation of powers is.
No?
No. Separation of powers, the wording of separation of powers actually appears nowhere in the U.S. Constitution. It is word for word in the Michigan State Constitution, though. I want to say...
It is in the Constitution, so it would have to be a state issue then.
Well, what you're talking about would not... It has nothing to do with federal courts. It has nothing to do with the federal Constitution.
So it would be a state claim?
It would be a state issue that the state Supreme Court would need to handle. Yes.
Inter-alia. All right. Thank you.
Yes, you're welcome. All right. Have a great night.
That was a great question.
Oh.
And like I said, we do appreciate you.
All right. Well, thank you. Have a great night.
You too.
All right. There was a caller from the 754 area code. Oh, you're calling back? All right. Hello. Can you hear me?
Yes.
Okay. I can.
Hello.
Yeah, you sound a little bit muffled. Where are you calling from?
I am calling from South Carolina.
Oh, okay.
And hoping also, I heard somebody else was from South Carolina. I'm actually, and I talked to you just briefly on a text before you had some things you had to deal with, and we couldn't talk any longer. But
are you the one with the sister or sister-in-law, and you're both JDs?
I have, yes, and I've been an attorney, and so has she.
Okay.
And so we got into the legal reform movement back in the late 90s and fought until we got disbarred. I don't know how you've kept your license through what you're doing, but she actually didn't get disbarred. She just quit after what happened to me. But anyway, so we started radio shows and going around the country doing seminars and whatnot to teach people how to defend themselves or bring a case, which is actually defending yourself before long. And so we did a lot of things like that, which made me obviously a lot of enemies. So anytime I have to go to court for anything, I don't care if somebody hit me, they can sue me for blood on their tires and they will win. You know, it's one of those kind of situations. So the short of it is I was getting treated for cancer, actually. That's what brought me to South Carolina. And I wasn't supposed to live. And miraculously, through the Lord, it was just amazing. I did no chemo, no radiation, end-stage cancer, and I'm still here.
Awesome.
So, yeah, but I got in the middle of some drug lords at a campground because I just was temporarily up here. And it became this crazy situation where they were obviously drug lords. The police were with me. You know, they were helping me. And I was trying to recover. And so all of a sudden they stopped and these people were turned loose on us. And so I ended up having to file suit, which was the last thing in the world I wanted to do while I was recovering. And in the midst of all of this, I hired an attorney just because I knew I couldn't really do it. I was just recovering. And it turned out he was colluding with the defense attorneys and the insurance carrier. And then the court came into it and they were obviously colluding, which I've seen many times before, but they weren't even trying to hide it. And they were doing procedural things where I couldn't argue and my attorney wouldn't argue. So we would default, on the case just because he refused to argue. And they were not things that you would refuse as an attorney. It was just the strategy.
Right.
So somehow we stayed in this, and we finally got him off the case, and we recorded him the whole time because we were seeing things right away that were not good. And so we have all these recordings that are legal in South Carolina of the attorney doing the collusion.
Okay.
So we've hung in there for several months, just at the last minute. I think you believe in the Lord. I know I do. And
yes.
It was just something that we threw in the last minute that took them off their, you could tell they were closing in, and it would just take them off that course and they'd fall into their own traps over and over and over again. And it's how I know the Lord was involved, because we're not that good, And so anyway, we're still in it, but they tried to close us in on June 4th, and something else happened that we were able to legally get them turned around. So meanwhile, behind the scenes, I've recused several judges for being a part of the underlying case. They actually were caught in a murder for hire against us. And there were a bunch of them. And it had to do with where I was disbarred. They were involved. and then which is Virginia, and then the South Carolina people. I mean, it's something made for, like Netflix or something. And so they're really trying hard to get rid of us. And they've had like South Carolina General Assembly representatives steer our case to another judge who came in, and we had like dead ringer wins on certain procedural issues, and like they defaulted several times by 2 months and things like that on answering the complaint. And so he found for them on everything, and he wouldn't give an opinion, and just the usual. I'm sure you know what I'm talking about, and probably many of the listeners.
Yeah.
So we're in a situation now where I'm filing the second suit, and I'm suing all these judges. I'm suing the ones that don't have immunity, because you can't do a murder for hire in a case you're not even involved in, even if you're a judge.
Yeah.
And so I'm taking them without immunity, and then I'm taking all their polluters who have tried to help them, and I'm challenging immunity for several reasons. And one of them is their whole reason for immunity is that it's good for us, because they just need to be independent, and that makes them the best judges, so they can act corruptly and maliciously, and it's just good for us. That's like their first reason, if you recall from this case law. And the second one is, if you can act as a judge criminally and corruptly and maliciously, that means that there is no law, because you can change it anytime you want. No matter what the law is, if you can ignore it and do these things, then you can be a criminal, and you have a complete reign over that, unless we can get a legal machine prosecutor to side against the legal machine, which isn't going to happen. So,
yeah.
So anyway, while we were doing all this, there was also the Murdaugh case. I don't know if you've heard of Alex Murdaugh in South Carolina. It's a huge case, a big-time attorney, several generations, and they were doing something called insurance reserve fraud. It's not insurance fraud. It's where they use your case, your personal injury case, separate you from the case, usually through procedure. They keep the case open, and they money launder through the insurance reserves. And so all their gambling money, their prostitution money, their, you name it, it goes through there, and it comes out nice and clean. And it's like an entire state systemic problem. And I've been in several states because I was doing legal reform and covering this in all kinds of states many, many years ago. And, Texas is doing it. Florida, your favorite, is doing it. I came from Florida to come here. Virginia's doing it. Missouri's doing it. I mean, it's not isolated. And so I caught them in this, doing it in our case. So we've got them on criminal, we've got them on the retaliation stuff, and now we're going after them through constitutional grounds and other grounds on the second suit against the judges, the state legislature, the attorney general, the solicitor general, you name it, they're involved, the police, whatever. And so my question or questions all have to do with, like, constitutionally, for the immunity, for instance, I think I have a valid claim. If you can just waive, any kind of civil liability, and you can't get a prosecutor to cover it either, because they're not going to, they're part of the legal machine, then you've got an entirely corrupt system that can't be recovered because it's systemic.
Yeah.
And so one of the Carolina Constitution, and I believe it's in the U.S. Constitution, is that the people can change everything anytime they want. And I think it might be Article 1, but I can't recall now because it's not in front of me. But in South Carolina in particular. And the thing is, I'm trying to stay with South Carolina law because I've been through the Fed system of arguing cases. They'll never let me go past summary judgment, which is what these guys are doing too. It's all Fourth Circuit, federal Fourth Circuit. And I stand zero chance in federal court. So this one, I obviously am standing like 0.1% chance, but I'm using a lot of leverage with their criminality as a part of them being concerned about the case. So any pointers, I'm going after all of it. I'm going after judicial review, which you probably know this well, but the real history of judicial review was a trick. It wasn't even like somebody just ruled that we should have that with judges. I think it was John Marshall that kept the underlying part of this was these people were appointed by the prior president going out, and I think it was Jefferson coming in. I can't recall exactly. And there was some finagling going on, and who really got their employment contracts into the court to be appointed properly before the new administration came in. And they were all playing games with the timing on this. And John Marshall actually withheld some of these contracts so that they could lose, that the courts could actually lose on judicial review in minimal ways that they were allowed to.
Mm-hmm.
But by saying that they couldn't constitutionally rule on it, they just ruled on the Constitution. And that's what gave them judicial review. I'm not sure if I'm being clear because I'm trying to be quick, but it was a trick. And that's how we got judicial review, which I'm going after. I'm going after Marbury v. Madison. I'm going after unpublished opinions. I mean, the bar, the usefulness of the bar as a monopoly, the Judicial Committee. In South Carolina, we have so many articles on how much corruption has gone on, and nobody says anything. There's never a result coming from the Judicial Committee. And in the years that people might have 50 judicial complaints that come out into the public, we have none in all these years. And so I'm going after the whole thing. Anything I see that I know is corrupt, I'm just going to add it on. Because for me, the Constitution is very clear that it's we the people, and they cannot override the Constitution or it's null and void. And so I'm asking for a jury trial on all these issues because it's part of my the retaliation part of this case, the second case, that I'm not asking them to just review procedure. I'm asking them to rule on the facts, which includes them playing with procedure and all these. So I'm asking the jury for everything, and to call a constitutional convention, not to change the Constitution, but to reaffirm that it is we the people, and to start appointing people and putting people in jail, So I've also included the International Human Rights Commission, and there's another one that's involved in South Carolina right now trying to stop the murder of people on death row that shouldn't even be on death row through very inhumane ways. Well, so I've got everybody involved.
A constitutional convention doesn't belong in a case. For you to bring a case that has nothing to do with the constitutional convention. So I wouldn't connect any of that. I also, and I have a tendency to put something, if there's a particular, for example, when I sued the city manager of the city of Belding in 2015, I was at my breaking point and I was like, screw it. You're going to come after me personally because I've been trying to stop you in your corruption and in your lawlessness. So I had an 8-count complaint. I mean, it wasn't 1 or 2 or 3 or 5, it was 8. But it was 8 very specific statutes. It was, a very meticulously crafted complaint that was fully backed up. I mean, when I filed they really didn't have to do discovery. They used discovery to abuse me and my family, but they didn't have to do discovery because I put everything that was necessary in, and I attached it to the initial complaint. So, I am one that likes to make sure I include everything because generally speaking, if you have, a case and you have, you bring a complaint or you're the defendant and you're replying in your answer or whatever. If it's the same transaction or occurrence, then you have to include everything. Otherwise it's deemed waived later on. And so that's a very important element. And that's why I do make sure to include all the claims or defenses anytime I'm filing a pleading like that. However, what you're talking about is not something that's the same transaction or occurrence. I mean, when you're talking about attacking judicial immunity, or you're talking about, attacking things that come out of Marbury versus Madison, or you're talking about attacking the usefulness of the Bar Association in South Carolina, for example, those are really separate and distinct issues. And any one of them is really large. and is something that would be monumental. If you start putting too much in there, then you're not going to be able to get people joining in as amicus parties, which you will need, because if it's something that's going to go anywhere, you might not have people joining as amicus at the trial court level, but as it gets higher and higher on things, and generally speaking, you're probably going to lose, even if it's perfectly crafted,
Right.
because of the deck is stacked against you. So when you go to the Court of Appeals, when you go to your state Supreme Court, things like that, that's when you're opening up more and more opportunities for freedom fighting groups to join as amicus and file briefs and join the cause. But if you have an insane amount of different things, people are going to be scared. They're not going to want to join in. And they might be seen as tied to one particular cause, even though they might, if they only want to focus on getting rid of judicial immunity, but you have stuff in there about the bar, and their typical attorneys are like, oh no, the bar is wonderful, whatever. Then you're not. They're just going to be like, you know what? No, there's too much conspiracy theory stuff. I just don't want anything to do with this. So any one of those topics, though, are big enough in and of themselves. For example, the bar issue. The issue with the bar is not that, and I'm sure you'll back me up on this, but the biggest thing that people claim is that, oh, it's the British accredited registry. Oh, we have an allegiance to to the crown of England. What the fuck is wrong with you guys? No, that doesn't exist. If you actually look up the British accredited registry, it has something to do with zoning in London or something. I mean, I've literally looked it up. I've done a whole video on it. It has nothing to do with me or any of the bar associations that I'm a member of. And I'm a member of bar associations only that I'm forced to. So, in Minnesota, I was not a member of the state bar past the first year because we had a free membership the first year, and an ABA, complimentary ABA, American Bar Association membership the first year. Great. So I was a member then. But as soon as it was voluntary, I was like, peace out. I want nothing to do with your membership. But then when I moved to Michigan, the state bar is not a voluntary membership. That's who runs the entire licensing, and it's literally a governmental entity. And so, I am currently a member of the Michigan State Bar. Now, do I believe in what they do 99% of the time? No. But really the biggest problem with bar associations is really the point that you alluded to when you're talking about the usefulness of the bar. And it is this, as with any profession, the person in that profession, whether it's an accountant, an attorney, a doctor, a carpenter, a plumber, anybody, each person is only as good as they put into it. So maybe they're super smart, but they don't have people skills, or maybe they're a schmoozer and they're smart, and they can swindle people, but they have no ethics. Or maybe they, once they take your money, then they don't communicate with you, or whatever. There's all kinds of things that make people bad in their professions. The number one problem, though, with the bar, as attorneys or plumbers or anything else, none of this in the United States, where we have a constitutional republic, none of this should be where you have to have a mandatory license to cut hair, to fix plumbing, to do electrical work. Now, if it were me, I would want a licensed person. So it's kind of like saying, like in the state of Michigan, the only thing that's required is your bar licensure. You have to be a member of the bar to be licensed to practice law in Michigan. But if I wanted to be a member of the Institute of Continuing Legal Education and then do all these extra certifications so that I could say I am a certified family law attorney, and I'm a certified estate planning attorney, I have all these certifications, that's extra. It's not required. And it would be just a selling point for somebody to go, oh, wow, in order to get that certification, there's a lot that goes into that. There's a lot of work and there's a lot of money, and, but there's something that goes into that. That's what it should be about, is that, it's caveat emptor, it's buyer beware. I mean, most attorneys are shitty anyway. So
I agree totally with what you said. If I'm in it for business, are you there, Catherine?
Yeah.
Okay. If I'm in it for business, then yes. but I'm in it to stop the corruption. And I'm not going to have attorneys join me in general because they would have to be more like you. And there aren't many like me or you or the few that I know, because most of the time you're going to lose your license for doing it. That's why I'm shocked you still have it, seriously. But on the constitutional issues and why I'm going after the whole ball of wax is because through these mechanisms, when I found out that the judges were involved in this murder for hire and all this craziness, and I mean, that is real crazy where that thing goes.
Yeah.
Each one of these things I have contacted. So I reported them to the Judicial Committee knowing that it's never going to come out. I've reported to the self-policing of the bar, which is ridiculous, and the self-policing, of course, of the Judicial Committee. And of course, they're not finding anything wrong, even though I've got the recordings, you know, and the judicial review that's allowing them to make decisions that change the Constitution or decide what's constitutional, you know, that's all related in this case because I've exercised all of those different options in different ways and they've been violated. So that's really why I'm just calling on a jury. And you know where you say in your damages, you say, you know, we're respectfully requesting a judge or a jury to find in our behalf and to find punitive damages to which they feel are necessary and do or whatever, you know, blah, blah, blah.
That's different than any state I've practiced in. So no, I have no idea what you're talking about there.
Oh, okay. In the damages clause, when you want to ask the jury to find for you, you usually give some sort of statement that we respectfully request the judge or the jury to find in our behalf for this amount and to assess punitive damages against the defendant in an amount they see reasonable. And that's where I can also put all these other things because you can ask for whatever you want. If you may not get it, but you can ask for what you want. And so because these issues in the Constitution have become issues for me in this case, the self-policing of both agencies, you know, all of these things that seem far-reaching, judicial review, whatever, they're a part of this second case.
So what's the cause of action? Because you can't just, it's not correct to say you could just ask for whatever you want. You have to ask for something that is cognizable within the cause of action that you're bringing.
Yes, that's what I'm saying. With the other causes of action that I'm bringing, and because I'm staying in state court, I can't really go after the RICO because there's a state RICO, but you got to have all kinds of other things that the prosecutor will never do for you, you know. And right. So I'm even going after that they've made it an impossibility.
But like the state bar, with that one alone, what is the cause of action that you would be trying to attack the usefulness of the state bar?
Okay, so in the second case, which is against all these corrupt government people, I actually filed a complaint with the bar and the Judicial Committee, and I showed what they're doing, and I gave them the tape, and I gave them all the text to show what they were doing. And they came back with, you know, we don't find anything wrong. And then they brought this judge that they steered in there to just dismiss everything without an opinion.
Right.
You know?
But what is the cause of action? But you have to have a specific cause of action.
Yes. My causes of action are to do with conspiracy. And part of that conspiracy is their procedural things that they've been doing since. Do you see what I mean? Part of their conspiracy is not just what they did in the underlying case, but the continual cover-up until we found out that the judges were involved, the solicitor general, et cetera. And then they started doing procedural predetermined outcomes that are so obvious on their face, they can't deny it. So that became a part of the conspiracy that continues to this moment.
Okay, but so you have a state statute that allows you to bring a civil lawsuit on the basis of conspiracy alone?
Yes. And so I can't do the RICO in state because it requires more that the prosecutor will never do for me. But so yes, I have a conspiracy, and I've got the several of them without immunity because they were involved in an underlying case that it was at a magistrate level, and these are circuit court judges. Okay. You know, they weren't even involved. So through that and all the help that they're getting from other people, I just keep enlarging the conspiracy.
Okay, but let's
So
just
I'm
pause on that for a
saying
minute.
that
So you have a state
Okay.
statute that allows you to sue civilly for conspiracy alone as a cause of action, and your state statute specifically allows you to ask for more than just monetary damages or things like that. It allows you to ask for other things like you're talking about.
Yeah, and it's not really, it's a statute, but there's also case law with it, which I try to avoid as much as I can, because that's part of my argument is these judges are just making stuff up, you know, and it's not constitutional what they're doing, including their review. But so anyway, that's why I'm trying to bring it in. And there's other causes of action, but that's really the main one. There's misprision of felonies. There's, you know, all of this kind of thing that's involved. But,
so you're
but the
starting,
main one
you're starting to get down a road though where it's not as applicable to, I guess, the vast majority of states, and certainly the states that I have experience in, because typically my experience in any jurisdiction that I've been licensed in, generally speaking, if a statute allows you to, you know, there's a specific cause of action that you can file for, you know, breach of contract or, you know,
Right.
tortious interference or whatever the you know, the case is.
Yeah.
That it's very limiting on the kinds of things that you can ask for, given what kind of case it is. And so, you know, for example, a writ of mandamus might be, or quo warranto, those might be where you might have some of the options to get after some of the things that you're looking for asking under your state statute. But I've never seen where you can have like a civil lawsuit over, you know, corruption, for example, or conspiracy rather, and be able to ask for the kinds of things that you're talking about. So we're out of my, you know, out of my area of expertise in that sense.
Okay. All right. Well, listen, I really appreciate you and for taking my text before. And, you know, the listeners, please pray, because we're really trying to just break this open, because some state has to go down to, just like Brown v. Board of Education and some of those other cases, it was a domino effect. Once one went down, then all of a sudden it was like a clean sweep of cases going down. And that's what the United States needs, is for a state to be so corrupt. And this one is, because they're hiding behind all kinds of secrets and you can't find anything else.
Yeah. They're all corrupt.
When we take one state down, guys, it's coming down, and we will get some power back. And we've also, I hate the international community. I hate going there, really. But they've already found that the United States is failing to redress grievances. And it's against human rights. The international community considers that a human right. And so there's some human rights council, and you can go through there and file your complaint. And if we get enough of those also, again, I don't want to go international against the U.S., but at some point it's just so corrupt that we're going to fall anyway. And the people just have to regain what they already have, except, you know, the courts have a bigger gun basically than we do, so they can do what they're not allowed to do, you know.
Yeah.
Just push to take one state down. And so whoever has the state that has a lot of good stuff going on and a lot of people that can join, that's what we need.
All right.
Well, thank you so much again for taking my call. Thanks to the listeners.
Yeah. All right. Well,
Bye-bye.
let us know how things turn out when you get that ball rolling more.
Okay, we'll see if I can stay in it long enough, because there's always a trick.
Yes, that's true.
Okay. Thanks again.
Yep. Have a great night.
Good night.
All right. So, with that being said, I'm going to see if I can, let's see. Well, the first thing I'm going to do is throw on my website, restorefreedomkh.com/resources, because it's really it's chock full of good resources, and hopefully I'll have actual free time at some point. Won't be buried with hours and hours and hours of endless legal research, writing, preparation, etc. for the Ormond Beach case. Yes, I did file more documents today, but hopefully I'll get more up there for you guys soon. There is another Michigan call. Give me just a second. Let me see here. Oh, I don't know what happened to that caller. I do see I have some internal messages. Okay. Mike, you can't just, you're in the house. If you want to come help me, come sit right next to me and help me, because clearly sending me messages 30 minutes ago, I can't do all that at once. So anyway, the chat was not moving. Yes, my bad, because I wanted to get back to some of these questions. Are all gun laws an infringement of the Second Amendment? Generally speaking, yes. Now, I can't think of all scenarios of all different kinds of gun laws out there, but red flag laws, unconstitutional. Mandating, that you can't have them in your car, or you can't open carry, or you can't concealed carry, and you can't be within 1,000 feet of a school, and you can't, all that's unconstitutional. Yes. Is every single gun law unconstitutional? Again, I can't think of what every single possible combination of laws out there might be. So it's possible there's some legit ones about guns that would be on the books. But let's see. So I'm scrolling for that big question. I swear there were more. Okay. What comes after a motion to reconsider being denied? So that depends on what jurisdiction you are in. So what you need to do is look at your court rules. I believe you were somebody that was commenting, if I'm not mixing you up with somebody, I want to say you're from Michigan. And so if you're from Michigan, look at the Michigan court rules. If this happens to you and you're in a different state, just look at your own state's court rules and look at, read everything. Now, you have to be careful, because depending on the kind of case it is, different chunks of the court rules apply. This is super important. In fact, it's such an important point. I've done entire videos on which court rules apply in which types of scenarios. So check out my website and search, type in court rules and look for all the videos that I've done on this, and you'll be able to see a whole host of resources. Because, for example, it's not as easy as you would think to understand which court rules apply in which situations. So, for example, in my illegal and unconstitutional arrest case from 2020 that took almost 2 full years to finally get dismissed, one of the biggest things that the judge said at the onset was that I didn't have a right to file a motion to dismiss under Michigan Court Rule 2.116 because it wasn't a civil case, and that was only allowed for civil cases, and mine was a misdemeanor. And yeah, you can do it in felony cases, but not in misdemeanor cases. Total crock. Yes, you can file a motion to dismiss in a misdemeanor case. In every state, yes, you have that basic right. Because, for example, if the court does not have subject matter jurisdiction, which the court didn't have in my case and was one of my main challenges all along, he was saying I couldn't bring that up. Yeah, no matter what kind of case it is, you can always challenge whether the court has subject matter jurisdiction. There's different kinds of jurisdiction, so keep that in mind, but subject matter jurisdiction you can always challenge. Anyway, so he said that I couldn't use rule 2.116 C, and I'm like, actually I can. I can. And so I just filed again. 2.116 C4 and C8 and C10 were the ones that I used in my case. Those examples, all those motions are on my website. If you go to the resources tab that I have on the screen right there, and you click, I think it's the second one down is the Allegan case, if I remember correctly. But anyway, you could peruse all those different motions. Not every single document that I had filed in that case every single document's not on there, because that would be way overwhelming. There were thousands of pages of documentation filed between the trial court, the circuit court, and the Court of Appeals. And then we went back down to the trial court, went back up to the circuit court, went back up to the Court of, it was ridiculous. I think I ended up having 3 different interlocutory appeals that made it to the circuit court, and 2 that made their way to the Court of Appeals in Michigan had I not been moving and dealing with the death of one family member and then another family member and then just all kinds of other things going on. I would have brought it to the Michigan Supreme Court in the first interlocutory challenges, but anyway, didn't have the option to do that just with life itself and representing myself. So anyway, the point is, even the judge in that case didn't think that civil court rule applied, and it did. Quite frankly, it did. And I had ample proof. You'd be amused to see the proof that I submitted. Forms that were part of a defense book where that the particular person who crafted the example form of how to file a motion in a criminal case was referencing Court Rule 2.116, C4, C8, and C10, the ones that I was using, was written by none other than at the time my case was pending, the Chief Justice of the Michigan Supreme Court, Bridget McCormick. And he somehow thought that's, didn't even read anything I submitted. But anyway, so yeah, you can. Now down here, I also raised the issues of things that the city of Ormond Beach was doing wrong in the initial round of appeal a year ago. In fact, we had oral argument on the issues 13 months ago in May of 2023, where I was arguing that the city was violating some rules that were in Chapter 2, which is or was it Chapter 1? I think it was Chapter 1, which is the civil court rules. And the judge said, oh, well, no, those don't apply here. And I'm like, but it's a civil case. Oh, no, it's just the appellate court rules. Okay. So at any rate, you have to know which court rules apply in your situation, because quite frankly, in Michigan with a criminal case, my criminal case, for example, it not only was the criminal rules, which is, it was Chapter 6. There was a little bit of is it Chapter 3 or Chapter 4 now? I can't even remember. Little bits of specialty court or misdemeanor stuff. I can't remember if it's Chapter 3 or Chapter 4. Chapter 1 is the general practice type of stuff. So that applies. Chapter 2 applies because, in Michigan, they start off by saying that the rules of civil procedure, Chapter 2, apply to every kind of case except for where they expressly don't, or there's a conflict with their own subdivision in their own chapter. And then, so Chapter 6, and then Chapter 7 was the appellate rules. So, I mean, I had several chapters that I was having to consult the entire time that my case was pending. Down here, at least in circuit court, it's pretty much, you have the general rules of practice, which I think is Chapter 2 down here. And then you have the rules of appellate procedure, which is Chapter 9 down here in Florida. So at any rate, you need to know which rules apply. So back to the question of motion to reconsider, you have to know your state's laws, but you have to know your state's your court rules. Whether you're an attorney or not, they're available online. Go find the most recent. And some states don't change them very often. Some states change them, more than they change their socks and underwear. It's insane. I've had to kill many trees throughout the course of the case that I've had here with Ormond Beach, which has lasted 2 years now, because, I printed court rules. I can't deal with just reading them online. I have to be able to highlight and put tabs and do all these things. I have them actually all over in binders on my desk here because I was just doing pleadings today and I have more to draft. But, so I had the general procedure or general, whatever they're called here, rules that apply, plus, of course, the rules for appellate courts. But then the Florida Court of Appeals has their own internal rules. In Michigan, there's something similar. It's an internal operating procedure manual. There's one for the Court of Appeals and a separate one for the Michigan Supreme Court. So anyway, you try to, and I didn't know these things existed. It's not just because I'm an attorney. It's because I sat down and I did my research. Because keep in mind, I'm not a Florida attorney. I'm just a person here. But I read and I research and I went and I looked at everything possible. I looked at the, whatever free resources are available on the legislature's website, on the state Supreme Court website, on the state bar websites, and I was able to look at some pro se or improper manuals. I was able to find different forms. I was able to find what rules there are and things like that. And it's more complex in Florida than it is in Michigan, which I hate to say because Michigan's not that streamlined. But anyway, it's not easy to tell, but you need to do that. You need to figure out what court rules apply. Once you know what your cause of action is, once you know where the jurisdiction and the venue is for your case, and what kind of case it is, and which court rules apply, then you need to read through and figure out what would be the steps for a motion to reconsider. Because after a motion to reconsider is denied, just like any motion, you might have to wait until, depending on if it's a motion to reconsider an entire judgment, a final judgment, or if it's a motion to reconsider an aspect. So for example, in my case on Friday, as I was driving back from Michigan, the city of Ormond Beach filed not a motion like they're supposed to under the court rule 9.330. No, they filed a petition for rehearing or reconsideration because a stay was actually granted in my case by the circuit court. A surprise to me, and it was something that we were just notified on Thursday about. But anyway, so they filed this petition to reconsider or to have a rehearing on the issue when they never filed a response in the first place, mind you. So as soon as you lose, as far as I'm concerned, you had 15 days under court rule to respond. You didn't. It's been more than 60. You don't get to just jump in whenever you feel like and blurt out like a Karen. But anyway, that's what they're trying to do. And so the procedures, if the judge denies their request, then they can bring it up to the next level. In this case, they could ask the Court of Appeals to look at the situation. It just depends on the jurisdiction and what the circumstances are. There's no easy thing. So once you generally get one bite at the apple. In fact, Florida court rules, I'm pretty sure there's something either in the comments or the actual court rule that says you cannot file more than one motion for a rehearing or reconsideration on any one particular judgment or final order. So, I don't know if Michigan or whatever state it is that you're asking about, if they have one of those. Generally speaking, that's kind of the rule, because otherwise it just keeps the case going in perpetuity and that there's no finality to that. And you wouldn't want the other side to be able to do that to you and not just be able to go, whew, I'm done with this thing. So at any rate, generally speaking, once you lose on a motion for reconsideration or rehearing, you can't do anything else about it at that juncture. Generally speaking, your next stage would probably be an appeal. Perhaps it's an interlocutory appeal if your case is still ongoing at that court and it was just, it wasn't a final order. It was like an order for a stay or something like that. But if it was a final judgment, then you can have a typical appeal, a normal appeal. So anyway, it's I wish I had an easy, Staples easy button that you could press and give you an easy answer to that question, but it really depends on what all the circumstances are, what kind of case, what jurisdiction, and things like that. Okay, and now it stopped. Whoa, okay. Dang. You guys are awesome in here chatting, and it wasn't scrolling at all, and then finally went. Okay. So, Okay. Well, I might consider doing the next live in vertical mode. I'm not sure that I want to do that, but we'll see. I might need a reminder because I don't think about doing that. Oh, Hello, Foshin, if you're still there. I don't know when you said something. Oh, that looks like a Finnish name. Oh, and the Finnish flag. So yeah, that's a Finnish name. And somebody was saying hello from the Keweenaw Peninsula. That is, well, the signs that you see there in the comment, that is not like gang symbols or them doing any, it's literally, I think they're trying to get at the lower peninsula and the upper peninsula using emojis. And I was born way up here in the upper part of the upper peninsula. So yeah. All right, I am scrolling quickly to look for any remaining questions that we did not get answered. I don't see anything else that's got question. Donald Williams says, attorneys do not have a license issued by the state. They are issued by a private membership association. It is equal to a YMCA card. You're full of shit. Clearly you weren't listening to anything, anytime I've said any of this. You're full of shit. It is different in each state. In Minnesota, that is accurate. Your statement is accurate. You can be a member of the Minnesota State Bar or you cannot be, and it has nothing to do with whether you are a licensed attorney. But in Michigan, for example, the Michigan State Bar, the State Bar of Michigan, is the entity legally responsible for issuing licensure for Michigan attorneys. I am a member of the Michigan State Bar, not by choice, but because that's the only way I get to practice law in the state of Michigan. And they are a government entity. And because of that, I'm actually a government official. All of that's actually in the briefing of my Allegan County case. If you want to check it out, go ahead and do so. I literally cover that because they had no right to legally arrest me. One of the many reasons they had no right to legally arrest me that day was because I showed up to the scene of the incident as an attorney. And the cops knew that. I was coming to talk to them as someone representing the people that were already there, the petition circulators already there. And because I was in that role as an attorney and the government officials knew damn well that's why I was there, there are state laws that prohibit government officials from being arrested during the normal course of their duties, except for three very specific circumstances, none of which occurred or were charged that day at all. Trespass certainly isn't one of them. Anyway, I don't see question. No state should require a bar membership to practice law. I'm just commenting on, who was it? James Chamberlain said some states are no longer requiring a bar to practice law, and no state should. But it's the same as whether you have to have a licensure to to be a barber, to a cosmetology license, or a massage license, or plumbing, or whatever the case may be. You shouldn't have to have a license to do any of those things, because a license doesn't guarantee that you know what the hell you're doing. The vast majority of people these days, I mean, our country is not what it used to be. I'm not even speaking about anywhere else in the world. I'm just speaking about our country. It's not what it used to be. People don't work hard as a general rule of thumb anymore. Yes, there are many people out there that do work hard, but the vast majority of the workforce, for those of you who own businesses or you're in management and you've had to review resumes and go through the hiring process, I've reviewed many throughout my years in my own practice, as well as when I worked for other law firms and other businesses. And it's insane. My entire life, I've been in the workforce since I was 11 years old. I started at my first office at my first job at 11 years old. And, it's insane the way that people just don't have the drive and the pride in their workmanship, in showing up to work on time and doing a good job and trying to learn, in trying to have customer service if they deal with the public or anything like that. And so at any rate, it's you have crappy people in every single profession, in every single location. That's just how it is. Sometimes you find somebody good, sometimes you find somebody not so great. But it's all caveat emptor. It's buyer beware. And yeah, you know what it boils down to is your certain contract, your particular contract. Am I saying that attorneys should be able to, you know, get off scot-free from malpractice claims? No, what I'm saying is you shouldn't have to be an attorney to practice law. You shouldn't have to be a licensed attorney to practice law. You should be able to advertise that you are a legal advocate, that you are an attorney, and that as the customer, the consumer, I should be able to say, okay, well, have you gone to law school, or, you know, are you licensed by any bar associations, or, you know, do you have any specific certifications? And it's a part of the shopping around process. It shouldn't be mandatory, but in most jurisdictions right now it is. So we're blending two things, normative and descriptive. And anyway, so I don't see anything here about questions. Oh, this is great. I think I'm almost, oh, there's one here from Disabled Outcast on YouTube. I did see there was at least one comment on Facebook earlier, but it was just hi. And it was in the middle. I saw it when I had a caller on, so I couldn't say hi back. But anyway, okay, two questions. Can a business, doctor's office, predicate access to their services on requiring a patient to allow them to copy one's driver's license, which contains personal, I don't remember what PPI is. It's too late in the day, but your protected personal information? No, that's not right. Whatever, your PPI, and likely implicates, oh, good Lord, DPPA, man, not at 8:30 at night. I haven't had dinner yet. Too many acronyms for me. And you're asking about it in Florida. Well, specifically in Florida, I mean, I'm not a Florida attorney. I have read every single statute on the books, literally. I mean, not at this point, because we've had a couple legislative sessions, but there was a point in time in the couple of years that I've been here that I literally had read every single statute on the books in the state of Florida. But as far as what you're talking about there, I don't, in the context of what a specific law might say, what the statutory regulations might be on that, I don't have an answer. Oops, I don't have an answer to that one. As far as being able to do business with you, it depends, because I'll tell you, as an attorney, for example, I had a policy of needing all kinds of information from my clients, because I wasn't going to do business with them unless I had a way to know that I was dealing with the person I was dealing with, that I had, you know, enough personal identifying information. Yeah, it's supposed to be PII, personally identifying information. It's not supposed to be PPI. I don't know what PPI is otherwise. Anyway, but I needed to know that because I did a lot of bankruptcies and divorce cases and, all different kinds. But I always asked for things like social security number and driver's license and things like that, because 9 times out of 10, I would end up needing it for some court form somewhere, or, even if it's a confidential form, there was something I was going to need it for, and I otherwise wasn't going to have it. And I needed to know ahead of time. In the medical field, there's a lot of that. They need that in order to file their claims or do whatever, things that they need to do in the normal course of their business. So it's really hard for me to say exactly, but you have a choice not to do business with somebody if you think they're asking for too much information. So, I mean, that's kind of where I stand on that. What form of criminal, Jason on YouTube asks, what form of criminal law is constitutional, being the U.S. Constitution makes no mention of it? Would it not be admiralty under a different name? No, you guys drive me nuts. All this admiralty and maritime and all this other stuff, that's not what the Constitution is getting at. So we're not even going to go there, because I want you guys to read. In fact, pull up the U.S. Constitution, pull up the PDF version of it from my website, and go to either use my own PDF viewer reader that's built into my website, or download it and open it on your own, where you can do all kinds of searching features, but do Control F once you have it open, and look do a search for admiralty and whatever other derivatives of that exact word there are, and look for it, because it's not in there the way that you think it is. And criminal law is actually in the Constitution in several aspects. One of the most important, I would say, well, maybe one of my favorite, in all criminal prosecutions, this would be the Sixth Amendment, the accused shall enjoy the right to a speedy and public trial. Okay. The Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime. Okay. And oh goodness. The Eighth Amendment, excessive bail shall not be imposed, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, that's actually been extrapolated to be used in civil contexts as well. But obviously, the majority of what that's talking about is in the criminal context. And there's a lot of cases about that. There's a lot of laws on those topics. There's more, involved in that. But the point being, it's, yes, there's the actual wording, let alone the direct implications of criminal cases is in the Constitution. So, yes, criminal laws in general are constitutional. Here's why. And I might blow your mind on this, and you might have to really sit and think this over. The point of all laws, though, is the protection of our God-given liberties. The point of all laws in the United States is supposed to be for the protection of our God-given liberties. If it's not there to protect our God-given liberties, then it's serving an impermissible purpose. So, and some things are a little bit more distantly related to that than others. But for example, we have, you have the right to life. It's appropriate that if someone commits murder, if somebody goes and murders my husband, well, okay, they're not going to want to get to know what's going to happen from me personally, but the system is going to have criminal charges pending about that, because that's the law's way of handling it. That there would be, that it would be a crime of murder, right, or manslaughter, or whatever the situation is, right? But my husband has a right to life. It is a God-given right to be alive, to breathe air. And so if somebody takes that from him, yes, that is a crime. Anyway, what it all boils down to is that all laws should be about protecting our God-given liberties. And that's why it's important to look at the 14th Amendment, equal protection of the law. Protection of the law. The law is there to protect our rights, not to protect us, to protect our rights. Because we then have the choice whether we want to exercise a particular right. If you start saying that the law is there, it's allowed to be there to equally protect us, well, then everything they tried to do with COVID was permissible. And that's not what the text says, and it's not what it's meant either. It just jumped again. I'm sorry, guys. I'm trying to go through questions. Oh, okay. Okay, you're speaking about murder, which there's no contention it would go under common law. Common law. Why do you think common law is better than a statute? Common law is literally judge-made law. And in our constitutional republic, where we have different branches, there's no, judges are not supposed to make laws. Common law should be entirely thrown out. The only point of the judicial branch is to sort out disputes between parties. and to have some sort of consistency in sorting out those disputes. But what that has, the need for consistency has somehow led to this entirely new animal of common law, judge-made law. And what's worse is that common law here in the United States begins with what judge-made law existed in like the 1600s. Our basis for our common law here in the United States is based on what common law was in England. I don't think that English judges back in 1600s or the 1500s had any concept or notion of how property rights should be handled, for example, when they didn't have a constitutional republic. We should not have common law because, first of all, it's fallible. Second of all, in our country, it has no place. Common law and judge-made law is not permissible in our country at all. At all. So murder should not be a common law thing. At any rate. Crap. Where did that question go? Question. Okay. I'm saying you're making an inference that there is such a thing as criminal law in the US Constitution. No, I'm not making the inference. I mean, it's literally in there. It literally, criminal prosecutions. Where do you think criminal prosecutions would come from? I sure as hell am not okay with being charged with a crime based off of the common law. Because first of all, it's judge-made law. It was not enacted by the legislative process. It's not constitutional at all. And then where is it? Where is this body of common law? How can you find it? How do you have due process? How do you have notice of what a law is when it's the common law you're talking about? Because there's a case out there for virtually any issue that you have. You're going to find cases on both sides of your issue, even from the same court. So what sense does that make to follow what judges have said the law is? No, what we need to bank on is what the statutes are, and constitutionally enacted statutes at that. Okay, please don't jump. I'm gonna jump again. Okay. Dude. Common law. Donald, you're full of shit. Just go to a different channel. This is dumb shit. To say common law is absolutely not judge-made law, that's BS. Really? Literally look up the definitions. Look up all the videos I've done just on that. Look up the definition of common law. It is literally judge-made law. Okay? It is what it is. I don't know what you think common law is or where it comes from, but it's one thing to be mad at the government, to think that the government, there's conspiracies, there's collusion, there's corruption, all these things that we've talked about in tonight's episode. That is going on. There are bad judges everywhere. There's bad attorneys everywhere. There's bad government officials everywhere, at every branch, every level, in every community. There's bad government officials. Absolutely. But you can't walk around saying shit that makes no sense. It's not based in reality. The only way we can fight back is if we're educated, if we're knowledgeable, if we're using the truth. That's the only way we the people can fight back. That's why I've been doing what I'm doing. That's exactly why I haven't made a dime as an attorney in the last 4 years, because I'm fighting to educate people like you on what the law is, what the Constitution is, what the basis, the foundation of it all is. And when you have people that say things like common law is absolutely not judge-made law, you are full of shit. You are the one who is full of shit. And if you're not going to listen to anything I'm saying, why do you even bother watching my videos? Because I don't want to deal with people that aren't willing to listen. There's enough people like that in the world. I'm here to help people who want to learn and grow and fight back and use actual knowledge and real tools and the real language of our actual Constitution and use this to fight back against the tyranny, against the corruption, against the collusion, against the conspiracies, all of it. It's not a bar attorney's definition. No, you guys, this is, oh, good God. Jason says, because under a common law, there needs to be a body, and not, in other words, a real crime. No, that's not what common law is. Common law is literally, if you search for what the common law is, you are going to find it's a bunch of decisions made by judges. So you're going to have stuff that's talking about criminal law. You're going to have stuff talking about civil law and contracts and bankruptcies and divorce and custody and parenting time and, real estate matters and probate cases and all kinds of things, insurance cases, everything. There's decisions. It's the body of judge-made law. That's what it is. So if you're trying to say a no body, no crime, that kind of thing, if there's no victim, there's no crime, that's not, you don't get that from common law. Thank you. Somebody, Constitution examiner. Judges do not make law in a republic. In our constitutional republic, judges, you're damn right, are not supposed to make law. That's why common law is bad. That's why it's bad. That's exactly what I'm saying. Common. The definition of common law in Black's Law Dictionary. Oh my goodness. Well, John, I'm going to get upset because the whole reason why I've spent the last hour and 37 minutes of my time answering questions is for free of my own time when I pay for all my resources. I pay for the streaming software. I pay to send the newsletter out to tell people about this. I put in the time to come up with the true or false questions on Tuesdays and the way to get involved challenges on Wednesdays and the freedom fighting tools on Fridays and have the website full of resources and all that. I'm going to get upset when people refuse to want to learn about what the truth really is. I'm not talking about taking my opinion for anything. I've always backed up every single thing, every claim I've ever made. I have backed it up. I used to do slideshows in my weekly shows where I would literally go through and have every single statute or court rule or if there's a court case we're talking about, so you could see what part of the Constitution I'm talking about. I back it up. I'm not one of those people that says, just believe me because I'm an influencer, or just believe me because I'm an attorney. No, believe me because I worked my ass off and I've literally shown you exactly where you can go look it up yourself and see exactly what I'm saying is true. I'm not the kind of person that's going to blow smoke just to say, look like I know what I'm saying on something. If I don't know, just as I've said in this call multiple times when people were asking me questions in an area that I didn't have an educated thing to say back to them, I said, I don't know the answer to that particular question. I did my best to give them a generalized answer if I could. Otherwise, if I don't know, I'm going to tell you I don't know. But if it is something I do know, I'm damn well going to tell you I know. That's who I am. And that's the way we should all be. Fight zealously, advocate for the truth and for justice in all circumstances. And don't be a zealous advocate if you don't know that you have truth on your side. Don't just fight to fight. Fight for truth. Fight for justice. That is our job here. No, I'm not incorrect. Okay, I'm gonna get Black's Law Dictionary. Let's do this right now. I've already done it before. Well, let's do this. Common law. Let's open it up. Donald, you better have your Black's Law Dictionary open too, because if I'm doing this, you're doing this. Common Common law. Here we go. Okay. Here we go. Common law. This is why I wanted you to look it up, because I've literally have this typed already for you guys so you can see the words on the screen. Common law. According to Black's Law Dictionary, the body of law derived from judicial decisions rather than statutes or constitutions. That's Black's Law Dictionary. No, I don't have the 4th edition because I'm not going to go backwards in time and try to find that right now. I have the 8th edition though. Okay, 8th edition. Somewhere right there shows you. Okay, I'm going to read that again. Common law is the body of law derived from judicial decisions, judge-made law, rather than from statutes or constitutions. Specifically, if you go to the part where it's talking about American common law, the body of judge-made law that developed during and after the United States colonial period. Sorry, that's the second part of the definition. The first part of the definition for American common law starts with the body of English law that was adopted as the law of the American colonies and supplemented with local enactments and judgments. And it talks about, there's more and more words talking about the common law evolved from custom and was the body of law created by and administered by the king's courts. Again, I'm still reading out of Black's Law Dictionary since you told me to go there. Let's look at that again. The common law evolved from custom and was the body of law created by and administered by the king's courts. And I'm going to double check. Yes, indeed, that is part of the American common law definition. That's still defining American common law. So, am I going to get upset when somebody's saying something that's totally out in left field? Yes, because it gets old. This issue of common law has come up like once every 3 shows, and it's like people don't bother to open your mind and learn about it. Where do you get the concept in the words that I just read to you from the very dictionary you told me to go and get? Where would you get the concept that common law has anything other than a judge-made law that started with judge-made law coming over from ancient England and that has just been added by American judges? Judges in England should not have anything to do with how laws are here. And certainly judges here, even these judges in these days or judges from 200 years ago, should not be making decisions that then impact everyone and translate out into common law that we are held to and we're supposed to abide by and follow it. Because it's not even considered a written law in the sense that it's not all in one place. Like you can go to the Florida legislature website or the Michigan legislature website or dare I say for federal statutes, the UCC, because that's actually not very user-friendly either to be able to find it. But you got to be able to go to one place and find the entire list of what laws are in any given jurisdiction. And when you're talking about common law, that does not exist. You can't go and figure out, you can't just look up what a topic is and go, oh, well, there's this law about no-fault insurance. And so that's not how common law works. It's a court case. No, we're not reading from 2 different books. We're reading from 2 different editions of the same book. 2 different editions of the same book, not 2 different books. Wow. So you want to buy me the 4th edition of Black's Law and send it to me so that I could see that your definition of common law in your book is different, significantly different from what I'm seeing. Go for it. Or just photocopy the pages about common law and mail it to me. Then I'll look at it. But I'm not buying it. I'm not buying it that it's different from the 8th edition to the 4th edition, so much so that it's no longer judge-made law, because that's been the thing. That's where common law derived from, and what the definition of it has been since long before Black's Law Dictionary was ever even written. Long before the 4th edition was put to print, common law was judge-made law. I'm not doing any more common law questions. Yes, I'm actually on the X platform. I think we're live on Twitter right now, if you're asking me. Anyway, okay, guys, listen. I feel passionate about the law. I feel passionate about the Constitution. I feel passionate about making sure everyday common Americans know what the law is, know what the Constitution says, and you know how to fight back. You know where to look, at least, when you have a legal problem. Because guess what? You don't have to be someone who's, out there just trying to file cases and trying to sue everybody. No. If you're an average Joe, just living your American dream, living your life on your own property, in your new town, in your new house, new old house, guess what? All it takes is one asshole to come after you, and then voila, you might be in years of litigation. You have to know how to be defensive and offensive, and you have to know where to look. And you're never going to win in court if you're coming up with crap that makes no sense. You're never going to win in talking to others to try to change things legislatively if you don't even know what process is already in the works now. Certainly, you're not doing anybody any good whatsoever if you are going around telling anyone that we need to rely on the common law. I have a really good friend that actually I think is still doing that. He's a sheriff. Oh, he knows who he is. This is about the only issue that I don't think I agree with him on. And it's a huge issue. But I've told him many times, common law is not where it's at. We need to fight the fight in an educated manner. We need to fight it collectively. We need to make sure all the tools in our tool shed are sharpened and they're the appropriate tools for the job at hand. And so if we're talking about all these red herrings, if we're talking about British accredited registries, and we're talking about common law is going to save us all and all this other bullshit, it's never going to happen. The good guys who don't like government corruption, who don't like tyranny, who don't like politicians and attorneys and judges controlling everything, the good guys need to band together under the same blanket of truth and fight courageously together. But we got to have that band that binds us of truth and justice. So with that being said, that's why I get all mad. That's why I get upset, because I'm constantly seeing this in light of the bigger picture. And because Donald or whomever you are, all you people, each of these comments are remembering. You are representing not just one person that has asked a question like that. You are representing perhaps hundreds of people that I've heard talk about that, ask me about it personally. The common law thing alone is something that has been brought up, I'm probably 1,000 times at this point in the last 4 years. And it gets old. It really gets old, because if people could just listen and read for themselves and look at the actual wording of the documents we have, the Constitution, our state constitutions, our US Constitution, the Declaration of Independence, look at these things and not rely on what other people say or, videos or whatever. Just take that information to guide you to the source documents themselves. Look at it, read it yourself, and know it inside and out. I don't know. That's our way to success. So with that being said, I'm not sure. We're going to look at the view counts when all is said and done, but I'm not super impressed with the number of people that, that we've been getting for the last year and a half. It just seems like this is not the best use of my time. I don't know what is, quite frankly. Perhaps when my Ormond Beach case is over, I'm going to try to connect with Aaron Siri, or, Pacific Legal Institute, or I don't know, just whatever. There's all kinds of different organizations out there. Children's Defense Network, I have an in there. A friend that actually is from Michigan but lives down here that works for them. Anyway, any number of scenarios. I might look into doing that to figure out if there's a better way that I can get my reach out there. I was hoping this would be a good way to do it, but I'm just not being able to share information as freely as I would like, being shadow banned and everything else. So at any rate, if you have any specific requests about keeping it at this time, if you have some reason why it would be best to keep our show at least once a month in the evening hours and not just at the noon time, let me know. Reach out, send me an email, contact@restorefreedomkh.com, contact@restorefreedomkh.com, or, I guess you could comment here. Hopefully, if you do it right now, hopefully Lori would be able to see it and she could grab it and all that. Anyway, I will probably, if we're going to keep this live call-in show thing going, if it's helpful to people, I'm probably going to want to do it in the daytime hours during my Tuesday at noon slot, because quite frankly, I don't want to miss any more of my daughter's swim meet stuff, or her practices, or her volleyball games, or just a nice stroll with my husband while it's still daylight, things like that. So maybe if I was getting paid the big bucks to do this, I could do it in the evening. But anyway, so reach out to me if you think there's some reason why we need to do it at least once in the evening. Otherwise, John, you're asking about sending a case to me. Depends on what you want to send a case to me for, because I don't have free time. I absolutely don't have any free time. So I don't really have time to read all the cases that I want to read. And I certainly don't have time to take any cases right now while my Ormond Beach case is still pending. And that First Amendment auditing case in the Middle District of Florida is still going on. So anyway, Jason B. Personally, I don't mind asking a lawyer a question they're uncomfortable answering. I don't even know what that means, dude. I'm an open book. I'm not uncomfortable answering things. I might be uncomfortable to try to come up with something off the top of my head if I'm not informed. But I'm really not sure what you mean by that, because I'm an open book. I don't have things to hide. I'm not going to tell you my pants size, even though I've lost 50 pounds in the last 10 months. But, there's some things I guess I'll probably keep secret. But, as far as the law goes, as far as the Constitution, as far as my professional, any of that, I'm an open book. And attorneys should be. But if you're like, I don't even like, whatever. I don't get it. No, dude. You're not getting a Christmas card from me because I don't know who the hell you are. So it's not because let me put it this way. I only want people here taking up my time with comments or questions or things like that actually want to learn from what I'm saying. If you're here to just argue with me or just to give me a bad time, go somewhere else. That's my point. I'm here trying to provide a free service to help educate and help people use this information and these tools to benefit themselves, to fight for their own freedom, to fight for their communities, to fight for this country. So if you're here to stop me in that journey, go somewhere else. There's a lot more other interesting channels to go. That's all I'm saying. If you're here, then it should be because you want to learn. You want to hear what other people are asking. You have your own questions you want asked. and you're actually open to hearing the questions. Because when people ask me questions, and my husband knows this, but other people do it too. But my husband does do this to me. He will ask me a question sometimes, not every time. He'll ask me a question sometimes and then not listen to what the answer is. That pisses me off. If you are going to ask me a question or bring something up in the form of a question under the guise that it might be a question, and then not listen for what the answer is, you're just wasting both of our time. Like, don't waste my time. Just let me do my mission of trying to help people and educate people. It's not about me being uncomfortable. Quite frankly, I'm sweating. I'm sweating. It's hot in my office. I had to turn my fan off because my hair blows all around like this. And then I can't stand when my hair is in my face. And if Ocean's still here, my haircut, I don't like it. It sucks. Maybe she can cut it differently next time. But anyway, yeah, I'm not comfortable sitting here for hours staring at my computer answering people's questions. That's not why I do this. It's not for comfort. It's for the mission that I'm on, that I'm being called to do. So at any rate, well, Constitution Examiner, thank you for appreciating me. I'm assuming it's me that you're appreciating. Maybe you're having a conversation with somebody else that I'm not picking up on. That could be very well. Anyway, so any of you in the chat now, any of you that are watching later, I don't care if you disagree with me. You're welcome back to participate in the chat and ask me questions, as long as you want to listen to what I actually have to say. As long as you're going to have an open mind to hearing what I have to say. That's all I'm asking you. If you just want to have a chat and like argue with other people in the chat, I'm like, whatever. But if you're going to ask me questions, just be open to hearing what the answer is. That's all I'm saying. So with the help of me, Rogue Nation and Six Oaks, you got a decision on a case you filed in New Hampshire. Okay. So it's a case you're involved in that you got a good decision on. Okay, then tell me that in the email when you send it over. And yeah, send it to contact@restorefreedomkh.com. So, oh, my stream is frozen? Okay. Well, that sucks. Anyway, there's a lot of hearts going up. I'm not sure if those are actually people hitting the like button or not. Anyway, so listen, guys, let me know what your thoughts are. If I should keep doing the live call-in show, if I should go back to the format I tried starting a year ago when I just tried to do some like short 8 to 10 minute videos on little topics. You know, is it even useful for me to do videos at all anymore? Is there a point? Let me know what you think. Reach out, comment on, you know, my commenting on my posts on YouTube works really well. I generally get the notifications for those. I don't always see the comments on videos. I don't know why, but that's just the way it is. But emails go directly to me as well. So anyway, yes, you're the guy who brought up common law and you seem just a little bit triggered. I'm irritated, but I explained why I'm irritated. I'm here to help people and you guys are picking a fight, and it's an ignorant fight. I don't have a lot of patience with ignorance anymore. The government is full of a bunch of idiots and ignorance. I mean, anyway. Well, all right, Constitution Examiner. I appreciate your words and your support. And just like everybody else that's listening now or later on a podcasting platform or whatnot, let me know. Reach out and let me know what you think. I do have the ability to go live on a podcasting platform, but that's not quite the same because, you know, people can call in there, but I think we finally got a format down that works this way as well. So, yes, I do keep my eye, Donald, I do keep my eye on the Supreme Court of the United States. I try to keep up on all the new decisions coming out. I don't read the wording of every single one of them, but I read the summaries, anything that has generally an applicable topic to something I'm super interested in. Then I try to read at least the official syllabus from the court. And then if it seems like, yes, it indeed goes into detail about things that would be relevant, then I try to read the entire decision, at least the main opinion, the majority opinion. I don't always read the dissents. Sometimes, more years ago when I had more free time. But anyway, so all right, guys, let me know what you guys think. I just want to make sure that I'm doing my mission the best way possible to help educate and empower we the people to fight back. So with that being said, I'm constitutional attorney Catherine Henry. It's been awesome having you guys on tonight. Check out that website. Don't forget, if you do like what we're doing, not only spread the word, hit the like button, hit the share button, tell people about our channel, our website, our resources, everything that's out there. Certainly, if you have $5, $10, $50 to spare, whether it's every month or whether it's one time, please go ahead and click on the restorefreedomkh.com/donate page and donate. There's a ton of different ways to do it. You can do it through Cash App, Venmo, PayPal. Square is a bunch of assholes anymore. I don't trust them. I was with them longer than I've been with my husband, and I'm no longer with them. Square and I have now been divorced. They are apparently, they've gone woke. I don't know. So anyway, I don't have as many options as I did when I was using their platform, but certainly support in any way, shape, or form that you can that way to keep this work going. And give me feedback. Let me know what's going to help. If you have groups that want to hear about the Constitution and you're in Florida, shoot, I'll go out of Florida if you pay for the costs of my travel and whatnot, because I can't pay out of pocket to go do something for free. But if you have somebody, you know, if you're all the way up in Alaska or someplace far that it wouldn't work for me to physically go, and you have a group that maybe we could do some sort of video conferencing to talk about the Constitution or, you know, some specific topics, let me know. I did a lot of in-person presentations throughout 2020 and 2021, hundreds actually. Drive around the whole state of Michigan and beyond, and I love talking to people and answering their questions and informing them about the law and about the Constitution. So please let me know if you have groups of people that want to hear more about the law or the Constitution. So, all right. Thanks, guys. Have a great night, and we'll see if I can figure out how to end this video like I am supposed to. All right. Next time. Our work to restore freedom would not be possible without support from people just like you. From the various software and hardware needed to the legal research materials, every dollar you can donate helps. Make sure to like and share this video too. And remember to follow and subscribe and click that notification button. Together, we can restore freedom.